Justice Kagan?
Can you imagine, Ms. Harris, any modern analogs of these anti-poaching laws? I mean, I guess what I'm asking you to do is to say, are there any modern laws that sort of use this kind of authority over, consent and licensing and so forth, but that don't have to do with hunting, that would be permissible because they're very much like these anti-poaching laws?
So 2 answers. One is, obviously, these laws themselves have endured throughout, which is why I think maintaining the distinction is important. But 2, you could say it's not that distant, but there is a separate tradition with respect to property close to the public, like your house. What are the relevant permissions? What's the default for property close to the public, setting aside hunting? And I think that's consistent with the way these laws work. I mean, Justice Sotomayor mentioned the 1763 New York law, and that's talking about enclosed property like orchards or gardens or other stuff, and saying if you carry arms on that land, that's a trespass. But it's also saying you can't trespass generally in these places. So I think it's getting to the idea of, if you have particular property that's close to the public, you might not want people with arms on it. That is what these sort of founding era laws say. You don't want them trampling your cornfield and destroying your improvements because it's closed to the public. Similarly to, you might be able to say, and again, this is a matter of like what the history would actually show. So I'm just
if I can, your objection to the use of these old laws really is just that the Hawaii law applies to although it's private property, it applies to property that is entirely open to the public for all other purposes and with respect to all other activities. And that's your view of why Hawaii is different. And if the Hawaii law was narrower than that, or if some other states were, then you would have a different question.
I think it would present different questions, and yes, that is our main objection, and the reason is Hawaii is trying to use laws that actually show the opposite tradition, which is laws closed to the public. You might need affirmative consent in order to be able to hunt on them. Property open to the public, though, is the exact opposite rule from the founding on otherwise, in order to ensure that people could publicly carry absent objection. And so yes, I think that is the most critical point about these laws. The fact that they concern hunting, I think, is a relevant additional factor that goes into what was the point of the presumptions, but the fact that it's hunting and also sort of other forms of trespass, I think, is the bottom line.
Thank you.